This is an appeal in the matter of the King on application of license between LLC and another and SS for the environment, sleep and food affairs.
My lady, first of all, I apologise for having kept the call.
No apologies are necessary. We understand there were problems getting into the building.
There were, I'm very grateful. My lady, my lords, in this case, I appear for the appellant, my own friend Mr. March. The respondent is represented by my own friends James Ely, King's Counsel, and Mr. Westwell. Lady, may I check that the court has three bundles: the core bundle, the supplementary bundle, and the authorities bundle?
Yes, thank you.
And an additional authority was handed up this morning, very recently, the case of C, which is in fact already cited extensively in one of the existing cases, West Berkshire.
Yes.
The issue in this appeal is a relatively narrow one. Was an exceptional public interest engaged that should have led the learned judge to grant relief below? And in addressing that question, seek first to take the court briefly to the documents to show what did in fact happen in terms of the respondent's compliance with his public sector policy duty, and then to turn to factors that weigh in public interest with particular reference to the authorities. It's right to say that the researchers of both sides have not come up with a case which is precisely on point. Maybe is an exceptional public interest engaged when the impugned decision in fact relates to legislation that creates criminal offences. My submission, though, is that there are analogies that can be drawn with other cases from which this court should conclude that an exceptional public interest is engaged in this case. So the legislation affected by the respondent's breach of the public sector equality duty amounts to about five orders in total. The Dangerous Dogs Designated Types England and Wales Order of 2023, which was made on the 31st of October 2023 and came into force on the 31st of December 2023, and that designated the XL bully as a dog prohibited type. Then the Dangerous Dogs Compensation and Exemption Schemes England and Wales Order of 2023, which was made on the 12th of November 2023 and came into force 2 days later. And that created both a compensation and an exemption scheme. Then the Dangerous Dogs Compensation and Exemption Schemes and Miscellaneous Provisions Order, made on the 19th of December 2023 and in force on the 31st of December 2023. And that related to the position of rehoming organisations, so rescue centres that owned dogs of this sort. And I don't submit that it was likely that any breach of the public sector policy duty was likely to have a significant impact on that particular legislation. Then, finally, the Dangerous Dogs Exemption Schemes England and Wales Amendment Order of 2024, which was made on the 28th of May of 2024, came into force on the 30th of June 2024, and that changed the dates at which dogs had to be neutered. And again, I don't submit that a breach of the public sector policy duty was of particular significance to that piece of legislation. There is a sixth order, the Dangerous Dogs Exemption Schemes England and Wales Amendment Number 2 Order of 2024. This came into existence, it was made on the 12th of November 2024, came into force on the 5th of December 2024. So after the Secretary of State had corrected the position with a detailed equality impact assessment. That made various corrections to earlier legislation, and it included a provision which permitted an XL bully to be transferred from one keeper to another if the original keeper fell too ill to care for the dog. And in my submission, that's a significant provision because it is one of direct relevance to people with disabilities. And therefore the position is that in December 2024, 14 months after the initial legislation and 13 months after the first exemption scheme came into existence, a correction was made which was relevant to the discharge of the public sector policy duty. So may I turn now to the facts of this case and briefly to the chronology. If I could ask the court please to look at the supplementary bundle and first of all page 113. And that's tab 30 for those using hard copy using tabs. And this is the beginning of the story. This is a submission to the Secretary of State written a week after the Prime Minister had announced that XL bullies would be banned. So on the 22nd of September 2023, a submission is made, which the Secretary of State is told, paragraph 1, that officials are working at pace to provide her with advice. And then over the page at 116, paragraph 27, public sector with policy duty, this will be carried out when the policy is more developed. The clear recognition there of the need to comply with public sector policy duty. The next event is at page 133. And this is a further submission to the Secretary of State a week later. So only a week later. That's 9th of September. And at page 138, a public sector policy duty assessment has been completed and is attached. And one sees the attachment at page 144. And the only element of assessment is contained in paragraph 4. We're not aware of any evidence that XL bully group types are disproportionately owned by individuals with protected characteristics. So we don't consider that the proposed measures would impact unfairly on individuals with protected characteristics. This is the policy duty assessment that the learned judge went on to describe as perfunctory. Then the next event is page 145. That's 26th of October, I'm sorry, 2023. And at page 149, paragraph 36, under the heading Public Sector Policy Duty, the writer has cut and pasted the words from paragraph 4 of the 29th of September assessment. And that is it. That assessment is those two assessments in the identical terms are all that were put in place for the three key pieces of legislation. There is then litigation. Letter for action in November 23, leading to unsuccessful application for an injunction at the end of December 23. And then commission being refused. And then the case being repleaded by me. I came into the case on 5th of January 2024. at no point in pre-action correspondence or until after the treaty had been amended did the Secretary of State admit to any failings in the public sector policy duty. In fact, the Secretary of State's position was maintained throughout the litigation that these assessments were lawful. And one can see that that is
Our
maintained.
starting point is the judge's findings, isn't it?
It is.
So,
Well, my lady, by reference to some dictionary authorities, my submission is there is a significance in the Secretary of State's attitude towards the public sector equality duty throughout the litigation, because the position was maintained right the way through that these early assessments were lawful. And one can see that in the evidence that the Secretary of State submitted, which is at page 109 of the supplementary bundle. Which is tab 29, and it's the third witness statement of Gareth Plain and Hughes on behalf of the Secretary of State. And he deals there, page 110 onwards, from paragraph 101 to 104, with the public sector policy duty. By the time he makes this witness statement, that Secretary of State, as a result of this litigation, has come up with the May 2024 assessment. And that assessment is seen at page 40 of the supplementary bundle. We have 4. And at page 41, halfway down, there's a reference to the judicial review claim, which is clearly the reason for this assessment being carried out.
That's supplementary.
Water then lists potential concerns that are being addressed in the impact assessment. I don't know whether the courts had the opportunity to read this in,
we've all read.
and in that case, I won't go through it in any detail whatsoever. I would though like to highlight a few matters. First of all, on page 47, under eliminating unlawful discrimination, second paragraph, referring there to the emotional impact that could have arisen if an owner found themselves unable to comply with the exemption scheme so to euthanize their dog. As of the 24th of May 2024, we had received 405 valid claims for compensation for XL bully type dogs that have been euthanized. So, while the legislation was, in my submission, unlawful, before the drafting of this lawful impact assessment, 405 owners had, for whatever reason, had to have the dogs destroyed. At page 51 to 52, the author considers the position of people with disabilities who may not be able to comply with the 30 days, the requirement that they should be, the dog should be at the same address as they are for 30 days in a 12-month period. On page 52, halfway down, there's a reference to evidence submitted in this JR that there was one individual who provided reference that they wouldn't be able to comply with it because of the medical condition. And then the next paragraph, we acknowledge this issue may arise, however, it's part of the established basis under which dangerous dogs are controlled. Negative impact is proportionate. And they accept that if people cannot comply with it, they would, however, be able to apply for compensation if they chose not to keep their dog. And the Secretary of State, had she read this before any legislation was put in place, might have considered that actually that's not promoting equality of opportunity. If a disabled person, rather than having an amendment made that says, if, for example, if you have a doctor's certificate that says you can't be in hospital for 40 days a year, then the 30-day rule will not apply. But instead you can just have your job destroyed. And if you did so before 31st of January 2024, you could apply for compensation. And that compensation was not available at the time that this impact assessment was created. And then at the bottom of this page, there's consideration of victims of domestic abuse, and over the next page. A reference to the Freedom Project and to the fact that owners of XL bullies who want to flee domestic abuse may not be able to do so. Because they won't be able to take their dogs with them, being a well-known problem in domestic abuse cases that women do not leave their abusers because they do not want to leave children packed behind. There's a reference to 9 emails that DEFRA had received in relating to domestic abuse and dealt with it sensitively. And in the next paragraph, we do, however, recognise the condition requiring dogs to live at a specified address may make it more difficult for a person to leave their home to flee domestic violence if they own an XL bully and wish to take it with them. They could leave the dog behind without the dog being seized and euthanised. The ban adds a potential complication to the lives of those suffering. But without undermining the ban itself, the only option is to manage this sensitively. So, first of all, the author is clearly looking at this from the point of view, is looking retrospectively, that was inevitable, because if one doesn't do the equality assessment before making the decision, whoever does it later is stuck with the situation as it is, and by this time the ban has come into place with its conditions. And in my submission, it was not possible for a court to say even that it's highly likely that this decision relating to these groups, disabled people who couldn't stay in their homes for have to wait 30 days, or victims of domestic violence, it's not necessarily highly likely that the Secretary of State, making decisions back in October and November 23, would not have made provision for them, when it might actually have been quite straightforward to do so.
I'm not following that argument. That appears to be an argument that the judge was wrong on subsection 2 capital A, whereas this appeal is about subsection 2 capital B.
My Lord, no, because in my submission, this is a matter that goes very much to the public interest, because section 2A provides that the court must not grant a remedy if the outcome would not have been substantially different for the applicant. And we accept in this case it wouldn't have been, because neither of the appellants relies on any protected characteristic. So we do not say, if this impact assessment had been done in September 23, I, the appellant, would be in a different position. But in my submission, there's a real significance to section 31 being drafted as it is, because the court, with the applicant in front of it, the claimant in front of it, is in a position to assess whether or not the outcome would be substantially different for that person. It may not be in a position to assess whether it would have been substantially different for others. And in my submission, that is a factor that plays very significantly into the interest.
Why didn't those others bring a challenge? And if they did, then the court might have to consider whether they should be granted relief, or if indeed they may be out of time, but so to extend it.
My lord, your lordship will be aware that public interest challenges of this law are expensive to bring and difficult to bring. So in this case, as the court knows, a challenge was possible because the claimants managed to raise more than £150,000, which £150,000 was left to face the cost risk. And they did obtain evidence, which the court has in the form of affidavits and witness statements in the bundle, from individuals with disabilities, with mental health conditions, housing concerns. So it did, as part of this public interest challenge, raise these issues. And in my submission, it is would be no answer for the Secretary of State to say, well, if we don't comply with our public sector equality, it doesn't matter if we don't comply with our public sector equality duty, because people who are affected can challenge it if they want to, and then will be required to behave lawfully. My Lord Mayor, may I turn to factors engaging in my submission, the exceptional public interest. First of all, my submission is there is an exceptional interest in there being proper consideration of the public sector equality duty at the right time, open-mindedly, before any decisions are taken, and not, as the court indicated, as a rearguard action.
Is anything exceptional about that? It's an argument that could be more benefit if this issue is raised.
My lady, my submission, that's the opening position, and one can see it particularly in Re-C, which I will come to. But yes, I accept. There are undoubtedly cases which say that if there's been a breach of public sector equality duty, but it's remedied before the court gets to make a decision, no remedy will be granted. But that depends on my submission upon a number of factors, including the context and the factual background against which this is being taken. For example, there are many cases involving planning matters.
There are also many cases where challenge gives rise to a reassessment, and the court is looking at the position as it applies after having made its determination with respect to what happened prior to the challenge, after the challenge, and after the judgment, making its decision about what remedy, if any, should be granted.
My lady, yes, and in my submission, that is a fact-specific exercise, it always will be. I would submit that it is still right to say, as a general proposition, that there is an exceptional public interest in proper compliance with the public sector equality duty. Because otherwise, what's the point in having it?
So how does that distinguish it from any other duty?
My Lord, in this case in particular, first of all, the legislation that came into force undoubtedly had an effect on people with protected characteristics. And the court will have seen that the authors in May 2024 said the numbers are very small. And in my submission, that absolutely does not matter. The whole purpose of section 149 is to protect small minorities against a drive from the overwhelming majority, whatever it may be. That's the whole point of it.
But the assessment at that stage was, in the May 24 assessment, was that to come out to say, even taking into account those matters, then the legislation, the duty was met.
My lady, I accept the duty was met in May 24.
And that was the judge's finding.
Yes,
And
and
that's not capable of challenge.
I accept that. But that's only the starting point, because that means that officials had put before, I think it turned out to be the Minister, not the Secretary of State, in the end of May 2024, a document that complied with the public sector policy duty. And that was before the Minister, so that he could make a decision as to what he wanted to do in receipt of that assessment. The assessment's not conclusive. The assessment says, for example, there will be an effect on victims of domestic violence who are disproportionately female. It's then for the Secretary of State to determine what, if anything, to do about that.
What I'm not understanding, I mean, the purpose of these provisions only bite if there has been a breach. So to say that there was a breach in this case doesn't distinguish this case, does it, from any other in which the court has to make the assessment as to what remedy, if any, should be granted.
My lady, in my submission, there's a number of factors that do distinguish this.
Right.
The first, in my submission, is that the compliance with public sector equality duty is immensely important when the Secretary of State is the sole, or the executive is the sole decision maker. It's even more important when actually the decision maker here is Parliament. Because this is not for example, the case of written ministerial statement about a national planning policy when everything is within the gift of the Secretary of State. This is the Secretary of State putting before Parliament secondary legislation which is subject to the negative resolution procedure. And it's Parliament that decides whether that legislation is passed or not. And in this case, in effect, Parliament was misled. Parliament trusted the Secretary of State to comply with the law and had no means of knowing that the Secretary of State had not done so. And there is an exceptional public interest in my submission, my lady, in that situation not being permitted to arise.
This is a category exception, using exception, a case of exceptional public interest. There's a category of these cases.
My lady, REC would suggest so, and I will come to that. I have to accept, of course, REC from 2001 predates this legislation. It's dealing with the wider discretion of the court not to grant a remedy. So the question in my submission is not, is it highly likely that the Secretary of State would have done the same if he'd had a lawful impact assessment in front of him? When considering the exceptional public interest, the question should be, would Parliament have passed these orders had it known there had been no compliance with public sector duties? Would it have passed them had it known that in the words of the learned judge, there had been no more than a perfunctory look at equality issues? And in my submission, we'll never know, it's highly unlikely that it would have done. And in my submission, there is an overwhelming public interest in Parliament and the public being able to trust that the Secretary of State has acted lawfully, particularly in circumstances where, outside judicial review, there is no means of Parliament or the public knowing whether the Secretary of State has done so or not. And particularly where, on the facts of this situation, the victims of that concealed breach of the equality duty include some of the most vulnerable people in society. There is also, in my submission, an exceptional public interest in legislation not being rushed, because that's exactly what happened here. The reason that we guessed in January 2024 that there had been no compliance with the public sector equality duty is that the legal team realised there would have been absolutely no time to comply with it. So we didn't know, we didn't have these documents, the Secretary of State had refused to disclose them. It was obvious that there would have been no time between the Prime Minister's announcement and the rushed legislation for full compliance. And one can see that. That's demonstrated by the fact that as of December 2024, changes were being made to legislation that did have an impact, a positive impact, on people with disabilities. Now, it's right to say that that changed, what I mentioned, to allow somebody who is very ill to transfer a dog to someone else, was reflected in existing legislation relating to pit bulls and other dogs that were already prohibited type. So what the Secretary of State was doing was tidying up to make the situation of XL bullies the same. But it's an indicator of what goes wrong when there is non-compliance with the public sector equality duty. Because had this been properly considered, that omission would have been discussed. As it is, between any person who, between an owner of an XL bully, who between February 24 and 5th of December 2024 found themselves too ill to look after their dog properly, would have had to have their dog destroyed or break the law by transferring the dog unlawfully to another person.
So part of your argument is that Parliament was misled into passing the secondary legislation.
Was it not actively misled, but Parliament did not know that there had been a breach of the public sector equality duty. Yes.
And that things would have been otherwise. Or it cannot be said that they wouldn't.
It cannot be said that they wouldn't. Because one would hope, my lord, that parliamentarians would be very concerned to know that Section 149 of the Equality Act had not been complied with. I would not
Does this take us into an area where we're being invited to question proceedings in Parliament?
My lord, no. Because it's a matter of procedural fact. Now, in the light of the learned judge's conclusion that there was a breach of the public sector equality duty, it is known that that breach occurred and known that Parliament did not know about it.
That we're being asked to make some sort of assessment about what would or might not have happened if things had been otherwise in Parliament.
My lord, your lordship is being asked to find that there is an exceptional public interest in Parliament not being misled, full stop.
Yes, thank you.
Because if the Secretary of State succeeds in this appeal, there is essentially a perverse incentive to government not to comply with the public sector equality duty, or to do so perfunctorily, and say to itself, well, if we get caught by a judicial review, then we'll put together a proper assessment and deal with it that way, which is exactly what happened in this case. And in my submission, there is an exceptional and overwhelming public interest in that not happening.
Can I just ask you, and please don't take this out of order, because you may be coming back to this, but suppose your appeal succeeds. What remedy do you now invite this court to grant?
The quashing of the orders made before the sessions of the motions from school.
Even though we know, as the judge knew when she gave her decision, that the legislation could be remade, and the PSED has now been complied with.
My lord, it could be remade, but it would require the Secretary of State to give proper thought, as at the time of remaking the legislation, as to whether to make any changes in the light of the impact assessment as it is then.
Well, we know what the impact assessments which you accept do comply with the section 149 duty have said.
The assessment complies, my lord, yes, but that doesn't lead inexorably to the conclusion that the legislation would be exactly the same. It just means that the Secretary of State would have before him or her an assessment, a lawful assessment, on which to base a judgment, on which to make decisions. And there's, in my submission, a very significant difference between the two. Between an impact assessment provided by officials that says, well, there is an impact on these people, but our advice to you, Secretary of State, is that it's a small number of people and public safety concerns outweigh the detriment to them. And the Secretary of State accepting that advice. It may be that, considering the matter properly, the Secretary of State would conclude that provisions should be made for people with disabilities who are away from their homes for more than 30 days. Provision of a doctor's certificate, 30 days doesn't apply. Or that provisions should be made that victims of domestic violence who seek assistance from the police and obtain a police report are exempted from the 30 days requirement.
Since I've asked about remedies, and again, please don't take this out of order, but I've tried to look through the articles to see exactly what remedy was being sought in the various documents, starting with the claim form through the skeleton arguments and so on. But have I understood the position correctly, that you were always seeking a quashing order? For example, a declaration would not have sufficed for you.
We were seeking both on the
You were
declaration.
seeking both. Yeah, but the declaration would be that the orders were unlawful.
Yes.
Yeah, which is, in constitutional terms, that's tantamount to a quashing order, because
Yes.
the court expects the executive to comply with the declaration. And it's not an opinion, it's not a judicial opinion. The declaration is a binding declaration which binds the parties. But what I have in mind is that in some cases concerning the PSED, the court has been willing not to grant a declaration that the orders made, the secondary legislation, is invalid or was invalid, but has been prepared to mark a breach of the PSED by making a formal declaration that there was a breach of the PSED. That happened in a case called Hurley and Moore, which is, I think, mentioned in some of the authorities which are in the London. But have I understood your position correctly, that you never wanted that kind of limited declaration?
No. And clearly, that limited declaration would have been preferable to no remedy. But the claimant was seeking a declaration that would, in fact, return to
Yes.
legislation.
What you've got, in fact, and it may just be worth having a look for a moment at what the judge's order actually was, which is under appeal. So it's orders which are appealed, not reasons. Page 69 of the 4-1. least in my experience, it's a slightly unusual wording. I assume this was agreed by the parties, or at least a draft was agreed and then approved by the judge. Do you have page 69?
I do.
Yeah. Do you see that actually what the judge did was, in paragraph 1, she allowed the claim for judicial review in certain respects, but then went on to say that section 31(2)(a) applied and therefore accordingly relief is refused. It might be said that at least the first part of paragraph 1 is as good in substance, is as good as granting a declaration that there has been a breach of the PSED. But the fundamental point is that you have never wanted that alone. That's too limited for your purposes. You want the secondary legislation itself to be either quashed or declared to be invalid, which is as good as quashing it.
My lord, yes. And in refusing a remedy, essentially the learned judge was refusing that formal declaration.
Exactly.
Did you say earlier, I made a note that what you're seeking now is the quashing of the orders prior to May 24?
My lord, yes.
So it's not a quashing, it's a... No, this is puzzling to me. A partial quashing. I mean, either they're quashed or they're not.
Oh, I'm so sorry, my lord. I didn't mean partial quashing of their effect up to 24. There were 6 orders made altogether, one of which is made after May 24.
The order's made. Yeah,
Yes.
thank
In
you.
fact, the order made after
Right.
24 would fall anyway because it's parasitic on the earlier ones.
Yes.
I apologise. I wasn't clear.
You're not asking, just to get something clear, you're not asking for a remedy only in respect of a 3-month period.
My lord, no. To return to matters engaging in exceptional public interest, my submission is that an exceptional public interest is engaged when the legislation involves criminalising behaviour that up until the point of this legislation coming into force was entirely lawful. So overnight, possession of a dog of an XL bully type, which is an entirely lawful activity, we know being carried out by at least 57,000 people, because 57,000 dogs have since been registered, became a criminal offence, unless the dog was registered. And in this case, legislation that I submit was unlawful from its inception, has been used, undoubtedly will have been used, to criminalise individuals. We have no statistics on it because none is available. There's simply nothing published to tell us how many cases were before the magistrates between February and May 24. But criminal conduct was created. And we do know from the quality impact assessment from May 24 that 405 dogs were destroyed at the request of their owners and compensation sought in compliance with legislation was unlawful. And my learned friend makes the point that legislation is lawful until the court decides that it's not lawful. Second. And my submission, that's a circular argument because what we are seeking is a declaration that it was unlawful. And it is the consequences of that, really, that this appeal concerns. And in my submission, a finding by the learned judge, even that it is highly likely that the legislation would have been passed in the same form, affecting everybody, had the equality duty been complied with, is not good enough to satisfy an exceptional public interest when criminal offences have been created. and when Parliament created those criminal offences in ignorance of the fact that the Secretary of State had broken the law. And I'll turn to the authorities in a moment, but in my submission, in making the declaration that the appellants seek, this court would not impermissibly be exercising some form of disciplinary function over the Secretary of State. The court would be exercising its supervisory jurisdiction to ensure that the law is not broken. And there cannot be, in my submission, a more important breach than one that affects criminal liability of citizens.
Was there any evidence? Is there any evidence before the court that anyone was prosecuted or convicted?
My Lord, no, because it's not possible to obtain it. There is simply no central record kept of what magistrates' courts do. And also, the police have a discretion, which they frequently exercise, to say to people, well, we won't prosecute you, we'll just seize your dog and destroy it. You have to sign your dog over. And there are some freedom of information answers that indicate the number of dogs that the police destroyed. But again, they're not broken down to tell you why it happened. What we do know is from the impact assessment that 405 people had their dogs destroyed when they wouldn't have had to do that had the legislation not been brought into effect. And one can assume that they did that in order to avoid committing a criminal offence. And some of those people may very well have been individuals who could not comply with the legislation because of their protected characteristics. They could have been, and we simply do not know because all we have is the figure. But in my submission, the court can infer that those who had their dogs destroyed are unlikely to have done so for financial gain. I think compensation is £200 and the financial impact assessment assess the cost to rent really roughly £2,000. So they certainly won't do financial gain. One can also infer that it is more vulnerable people who were likely to be unable to comply with the legislation. So, for example, people in social housing whose landlords wouldn't allow them to keep XL bullies, disproportionate number of those in social housing are people with disabilities. Women fleeing domestic violence who knew if they went to the Freedom Project, they couldn't take that XL bully with them, and so they were destroyed. You don't know, and I don't put it forward as positive evidence, but as a matter of common sense, it seems overwhelmingly likely that those who were forced to have their dogs destroyed were the most vulnerable, and they are likely to have relevant protected characteristics. In the learned friend skeleton, they submit that it would have been open to defendants in criminal cases to take the point that the legislation was unlawful on grounds of a breach of public sector policy duty. In my submission, that's unrealistic. For a start, DEFRA is not a party to criminal proceedings. It's the CPS, or usually the police, actually. And the police themselves would have had no idea whether there was compliance with public sector policy duty. They wouldn't have disclosed in their unused material anything to indicate to a defendant that there might be a ground of challenge. And realistically, judicial review challenges of this sort are out of reach of ordinary people.
But as a matter of legal principle, the respondent is right. The defendant in a criminal case can that the instrument under which they're being prosecuted is invalid, and that's being endorsed by the House of Lords in Boddington. So it not only can it happen, it has happened on occasion.
But on rare occasion, my lord, and again, it's in my submission not an answer to a breach of public sector equality duty to say, well, you could challenge it. Well, very vulnerable people could challenge it. People with absolutely no money in the criminal courts could challenge it. People afraid of criminal convictions who accept the police saying, hand over your dog and we won't prosecute you and we'll put the dog to sleep.
That's not what the respondent's argument is, as I understand it. If this case had reached court before May 2024,
yes,
the respondent would not have been saying you can't have this judicial review challenge because people can defend themselves. At least if they did, that might well have been given short shrift. The argument is that a lot of water has now passed under the bridge, and the judge found that by the time she was asked to grant a quashing order, Section 31(2)A applied, and therefore, in the light of what she now knew of the later PSED impact assessment. So that's the situation in which the defendant makes the respondent makes the argument that, well, if there were people in the relevant window of time that you are concerned about, before there was a lawful impact assessment, well, in principle, such people would have had an opportunity to raise exactly the same legal argument by way of defence. And for all I know, I don't know whether there are any such people, whether they were convicted. They might, I don't know, they might be able to apply for leave to appeal out of time. But the fundamental point the respondent is making is that none of that is before this court, where we're considering an appeal in the civil division from the judge's application of Section 31.
my lord, in my submission, the exceptional public interest is engaged precisely because people were criminalised. And in that instance, and in that context, how easy it would have been to challenge, how easy it would have been to recognise that there was an unlawfulness in this legislation is very important.
And the criminalisation is an inference, you say?
My lady, in the sense that we cannot identify a particular individual who was convicted simply because that information is not available to us. Yes, it's a clear inference. There were 4 months, 3 months, the end of February to the end of May, at a time when it was known that the police were taking a very hard line. The police made a public statement saying that they would not go down, well, there's a civil route in the Dangerous Dogs Act where the police don't have to criminalise someone, they can take civil action. And the police said they wouldn't. And therefore the police issued a statement saying that they would prosecute.
So the argument is not a hard-edged argument that every time a criminal offence is created following an inadequate and unlawful public sector equality duty assessment, the remedy must be a quashing. It's a contextual argument that depends on that being the position here and the other circumstances of the case?
My lord, it will always be fact specific, and that was a point made this year in the case of Bradbury. In my submission, there will always be a very high bar for Secretary of State or relevant decision maker to cross when a criminal offence has been committed following breach of the public sector policy duty. Lady, may I turn now to the authorities?
Yes.
And may I ask the court to please turn first to the case of Riley, which is at tab 1 of the authorities bundle at page 1. And I should preface all of my submissions by saying, as I did at the outset, I'm not suggesting that these authorities are precisely on point, only that they are of assistance. So the head note in Riley sets out the factual background. Again, I don't know whether there's an opportunity to look at these authorities. But in that case, the claimants who were receiving job seekers allowance had been required to take part in a work for your benefit scheme, which the High Court subsequently ruled to be unlawful because this was made pursuant to regulations of the ultra-vires. And then, while appeals against that decision were pending, the Secretary of State put forward new legislation which Parliament enacted, which essentially retrospectively validated the 2011 regulations. And the court's consideration of the lawfulness of that course is set out at page 20, onwards, paragraph 81. And the relevant passages, paragraph 81 to 85. Now, in this case, legislation was used to regularise a position, and the court held that to be unacceptable and unlawful. So, 81. F downwards. The principle of the rule of law and the notion of fair trial and equality of arms contained in Article 6.1 precludes any interference by the legislature with the administration of justice designed to influence the judicial determination of a dispute. may be justified in law on compelling grounds of general interest. Any reasons to justify such measures which use with the greatest possible degree of circumspection. And 82, which is cited in our skeleton argument, is accurately reflect fundamental principles of the UK's unwritten constitution. It requires inter alia that Parliament and the Executive recognise and respect the separation of powers and abide by the principle of legality. Although the Crown in Parliament is the sovereign legislative power, the courts have a constitutional role of determining and enforcing legality. Thus, Parliament's undoubted power to legislate, to overrule the effective court judgments, generally ought not to take the form of retrospective legislation designed to favour the executive and ongoing litigation of the court against the Parliament of its citizens, unless there are compelling reasons to do so. Otherwise, it is likely to offend the citizens' sense of fair play. Now, I accept, in that case, the court is saying legislation to effect a result is unlawful. It offends the sense of fair play. I accept, as I must, that the courts have held that a retrospective public sector policy assessment can essentially put something right to the benefit of the Secretary of State during the course of litigation, as has happened here. But in my submission, an analogy can be drawn here, where the rights on which the rights affected by the legislation are so fundamental in terms of criminalising conduct that it would offend the sense of fair play for retrospective approval essentially to be given by this court, because that's what's happening. If this court dismisses the appeal, the courts, through refusing a remedy, is making lawful the criminalisation of individuals, the destruction of 405 dogs pursuant to legislation that was unlawful at the time. And in my submission, that does offend the citizen's sense of fair play. May I turn now to the West Berkshire case, which is at tab 2. And page 36. In this case, a written ministerial statement made amendments to the National Planning Practice Guidance. So this was a case in which only the decision of the Secretary of State was in play. So Parliament was not involved. And indeed what happened was that the Secretary of State first issued a ministerial statement, received a letter before action, carried out a public sector policy assessment, so reconsidered the decision, and then issued the statement again. And the relevant passage is page 57 from paragraph 65 onwards. The paragraph 65 and 66 show what happened. Once the Secretary of State had considered properly done the policy statement, he was satisfied that the policy changes announced in WMS were compatible with the requirements of the section, and accordingly, after reconsideration, decided to maintain the policy changes. In this case, Parliament never had that opportunity. The Secretary of State reconsidered matters after receiving the Equality Impact Assessment. But Parliament didn't. And it was Parliament who had the responsibility through negative resolution of imposing this legislation. The court's conclusion at paragraph 87. It started in 85. Essentially, the court held that compliance with the policy statement was sufficient. Paragraph 86, the court considered the case of C, and I'll come back to that. And 87, nothing we say should be thought to diminish the importance of proper and timely compliance with the PSCD. But we have strong reservations about the proposition that the court should necessarily exercise discretion in quash decisions to form a disciplinary measure. During the course of argument, Mr. Forsyth accepted that if the assessment subsequently carried out, test by the court there'd been a point in watching the decision is effect of doing that and requiring a fresh consideration would not have led to a different decision. We think that's a correct concession. The court's approach should not ordinarily be that of disciplinarian, punishing for the sake of it in these circumstances. The focus should be on the adequacy and good faith of the later assessment, although the court is entitled to look at the overall circumstances in which that assessment is carried out. And of course, accept that as a proposition, but for reasons I've already outlined, submit that the present case is very different, involving A, criminalisation, and B, the role of Parliament.
The court here talks about discretion because, of course, this is a pre-2015 judgment, is it?
It's 2016.
Claim would have been started.
The court does not refer to the.
I suspect that at the time, what is now section 31 2A wasn't yet in force.
And certainly wouldn't have been at the time of the first instance decision.
Exactly,
Yes.
that's what I mean.
Yes.
Yeah, so it doesn't seem to have arisen. But I think what's said, certainly what seems to have been said by the judge in the present case, is that she was bound by section 31 2A,
Yes.
which imposes a duty. There's no longer a discretion.
Yes.
There's all the discretion. I mean, the simplex was the governing principle of common law. But it's become a duty in certain circumstances. And then, of course, there's a discretion to disapply that duty if you come within subsection 2B,
Yes.
which is what you invoke.
Yes. In the Berkshire case at 77, the court referred to the case of C, which was handed up this morning. And may I turn to that now, please? And again, it's obviously even earlier, so it doesn't engage the statutory provisions.
Yes.
In this case, this did involve regulations subject to negative resolution in Parliament. And what happened was that the Secretary of State, in breach of what was, it was then a duty to carry out a race equality impact assessment under the Race Relations Act, had amended secondary legislation to allow officers in secure training centres to use force on children, not simply in order to protect them and others, as has been the case before, but as a means of maintaining good order and discipline. And the relevant discussion is at paragraph 40 onwards. I'm very conscious this is not already for court. I don't know whether it would be perhaps best if I asked the court to read to itself.
Paragraphs?
It's quite a lengthy section, I think, from paragraph 40 to 56.
have misunderstood, so please do help me on this. But paragraph 54, where Justice Buxton refers to the decision of this court in Bapio
Yes.
and distinguishes it on the basis that that was a case where the mistake had been realised and corrected before the matter came to court. And so what seems to have animated him in particular in the C case is very last minute, I think it was just days before the Court of Appeal case, that finally the government gets its act together under what was then Section 71 of the Race Relations Act. Is that, have I understood the point of distinction correctly, or is that relevant?
My lord, yes, Bacchio is not in the bundle. In fact, the issue in Bacchio is dealt with, well, only over by the Court of Appeal, because it doesn't become an issue in the Court of Appeal, and very briefly by Mr. Justice Stanley Burnton, as he then was, when he just says, well, we've got the assessment now, so I'm not taking this any further. So it doesn't really help. And I do accept that a factor in this particular case was that the impact assessment was produced very late, and also, as Lord Justice Buxton said in paragraph 54, that the fact it's been produced is by no means conclusive on this issue of principal grant, the unsatisfactory conditions under which that work was undertaken. But the unsatisfactory conditions are the fact that the legislation is already in existence.
In addition, in paragraph 49, I don't want to read between the lines, but certainly the implication is that whatever had been produced was produced to come to a particular conclusion in order to preserve the regulations. So there's and the position we're in is not one where that is an argument that can be advanced before us, let alone one that's open. Because it isn't and can't be suggested that that was the position in relation to the May 24 assessment.
Well, my lady, the wording of the assessment itself does indicate, of course, that the authors were dealing with the situation as it was then. And in the section relating to domestic violence that I highlighted, the authors said there is a problem with victims of domestic violence, but without undermining the ban, there's nothing we can do about it. So in fact, they were looking at a situation of preserving what was already there. Because they had to, because they were dealing with this inevitably, with a situation in which they then found themselves, where the law had been in place since the end of December 2023. It's been in place for the first piece of law into place on the 31st of December 23.
In any event, what do you say are the relevant points that we should take from this case?
My lady, first of all, in paragraph 41.
Yes.
At H. As with any administrative decision, the court has discretion to withhold relief if there are pressing reasons for not disturbing the status quo. It is, however, wrong to think that delegated legislation has some specially protected position in that respect. If anything, the imperative that public life should be conducted lawfully suggests that it is more important to correct unlawful legislation that, until quashed, is universally binding and used by the public as a guide to conduct than it is to correct a single decision that affects only a limited range of people. And in my submission, that's exactly the position we have here. And of course, the court is not here using the language of exceptional public interest. It's not the test it's applying. But my submission is that it absolutely does reflect an exceptional public interest. Then at 45, at H, the legal obligation to take certain steps before laying legislation before Parliament is that of the executive. It is not Parliament's role to control that obligation, that's the function of the courts. Rather, the function of Parliament is simply to approve or disapprove the amendment rules as laid. Its failure to disapprove the amendment rules cannot supply remedy the executive's failure to perform the legal obligations that it bears before laying the amendment rules in the first place. And again, in my submission, that's precisely mirrored by what's happened here. Parliament in C did not have, or did not know, that there had been no compliance with Race Relations Act. Parliament in this case did not know there had been no compliance with the Public Sector Equality Act. And there's in 46 quotation from United States Tobacco. Although the regulations are subject to annulment by negative resolution of the House of Commons but were not so annulled, Parliament would be concerned only with the objects of regulation and would be unaware of any procedural impropriety. It is therefore to courts, by way of judicial review, that recourse must be had to seek a remedy.
I think this is directed to a slightly different point. What had been argued in a number of cases, like the US tobacco case, and no doubt in C itself, was that somehow the court should be reluctant to grant a remedy by way of judicial review because Parliament has been cognizant of the issue. And so what the court is doing is rejecting that kind of submission, that somehow judicial review is not appropriate because Parliament has been involved. But you're invoking the negative resolution procedure for a different purpose. I'm not saying you're wrong. I'm just saying that I'm not sure that that's the point the authorities help you with.
My Lord, I accept there is nothing, that it's not directly on the point, but my submission is that an analogy can be drawn from it. That the point being made in C and in Riley is the importance of the court's supervisory jurisdiction in circumstances in which Parliament simply does not know of procedural improprieties that need it. It is that Parliament is being asked to approve legislation or to accept legislation through negative resolution procedure when it cannot know that the Secretary of State has failed to comply with the law. And in that case, in that situation, the court's supervisory jurisdiction is key. And there is an exceptional public interest in my submission in the court exercising that jurisdiction and in making the appropriate declaration where Parliament has not known the truth. And in my submission, the fact that that may cause difficulties. By this by the time we've got this far, the legislation has been in place for nearly 2 years. Is not a determinative factor at all. One can see that in Riley, where the court recognised that it was going to cost the department £130 million if the legislation, retrospectively, to put matters right, wasn't upheld. And what is apparent from C is the focus on process and the importance of process. So paragraph 48. The court's not impressed by the prospect that the Secretary of State is going to carry out a review that hasn't yet happened, or if it has happened, the Secretary of State's refused to tell the court what was in it. But then, relating to the impact assessment, at F, the review is into the merits of physical control in custody and not at all into the question here at issue, the process whereby physical control in custody was extended to good order and discipline. In particular, it cannot supply the defect in the mission of the impact assessment. It cannot, obviously in this case it's factually different because before the divisional court there was no impact assessment, there was one by the time it got to the Court of Appeal. And then Lord Justice Buxton deals with a matter of general principle at 49, dealing with Bacchio. Lord Justice Sedley said that the decision in that case not to interfere with the trial judge's decision not to quash the alteration of the immigration rules which has taken place without an impact assessment does not in any way diminish the importance of compliance with Section 71, not as a rearguard action following a concluded decision, but as essential preliminary to any such decision. Inattention to it is both unlawful and bad government. And in fact, that is all the Court of Appeal says in Bacchio. I respectfully agree. In the present case, absence of an impact assessment was the result not of inattention, but of a mistake made by the Secretary of State. In my view, it sent out quite the wrong message to public bodies with responsibilities under Section 71 to allow that deficit to be cured by a review only undertaken 8 months after the amendment rules had been laid and in the face of an adverse court decision. So here, the Secretary of State, rushing through legislation, keeping this chronology, just pays lip service to the Public Secretary's policy duty, barely considers it. A couple of lines in September 23 in the submission. So, query whether one describes that as inattention or a mistake, or simply the consequence of rushing through legislation. The review was undertaken about 7 months after the first legislation had been put before Parliament, and in the face not of an existing adverse court decision, but what was clearly going to be an adverse court decision if they didn't come up with the assessment. And then at the end of paragraph 49, the court does say that process has also produced the result that the impact assessment needed to come to a particular conclusion in order to preserve regulations that the court has found have been introduced unlawfully. I do not, of course, in any way doubt the good faith of the civil servant who's produced it, but demonstrates that it's not applied in a discriminatory fashion. So the court is saying there, it's not saying that the impact assessment in this case has been done with a view to reaching a particular result, because it's what the court is saying is that it was carried out in good faith. But it has led to the conclusion, this retrospective approval of unlawful legislation. As a matter of principle, it cannot be right that a survey that should have been produced to inform the mind of government before it took the decision to introduce the amendment rules was only produced in an attempt to validate the decision that had already been taken. Again, I accept that a subsequent authority does permit a retrospective Equality Act assessment to validate an early decision.
Right, and attempt to validate. I mean that again, it's implicit in that, but it's not an open-minded assessment.
Although the court says in terms that they don't doubt the good faith of the.
That's what it says, but that's what it's the part you've just quoted seems to suggest the contrary, because if an attempt to produce an assessment in an attempt to validate a decision is not to produce an assessment which is open-ended.
My lady, in my submission, it's a very similar process to the one we have here, in that the civil servant in C produced an assessment that said actually this use of physical control is not being operated in a discriminatory manner. In the present case, the assessment said there are impacts on protected groups, but without undermining the ban, there's nothing we can do about it, which was essentially a validation because of the practicalities of the time at which this access was being carried out. Huge public pressure. Government absolutely determined to ban XL bullies. And the fact that
there are issues of public harm that front and centre of those considerations. And in any event, that's not a matter which is, as a which is before us as an issue, i.e. whether this was a process that was designed to produce a particular result.
My lady, in my submission, it's very similar to that of C, where it's not designed to produce a particular result, but the time at which it is being carried out means that the assessment is necessarily different from the one that it would have been had it been carried out at the right time. Because by the time in C this was done, the author was looking back, presumably, at how the unlawfully introduced legislation had been working in practice. And that's exactly the same as the present case. While I do not challenge and cannot challenge the finding that the assessment in our case was lawfully carried out, it was a necessity, not the same assessment that would have been carried out in September.
Well, that may be right. The difficulty is that when you quash a decision, you have to ask what's going to happen next. And as Mr. Justice Chamberlain says, I think, in the Friends of the Earth case, which I think is in the Bible, if you know that exactly the same thing is going to happen, what's the point of pushing?
My Lord, first, one doesn't know for certain that exactly the same thing is going to happen because it's a matter of Parliament, not the Secretary of State. Secondly, there is an exceptional public interest in not permitting criminal legislation to stand.
Well, the second of those arguments I well understand, and you've made that very eloquently, if I may say so, at this hearing. The first of those, it seems to me at least, to go to the subsection 2A point, which is not before this court on appeal. In other words, the judge's conclusion that it was highly likely, ... that's not before this court. The only question is whether she should then have gone on to say that the duty should be disapplied because of 2B.
My Lord, the judge's conclusion was that it was highly likely it was not indifferent with the applicant. That's the only relevant conclusion in terms of the...
Yeah, but it's the applicants who are seeking an order.
Yes.
And they're the only people who are seeking an order.
Yes, it's the public.
That's why 2A applies.
But this is public investigation, which is why my submission is that factoring very significantly into the exceptional public interest is not the question whether it would be the same for these applicants, we accept that it would, but whether it would have been the same, highly likely to be the same for people with protected characteristics.
And so you dispute that it would, that the same legislation is highly likely to be enacted. Is that right?
One can't say.
I see.
Particularly because if the Secretary of... Let's say for the sake of argument that the court does quash these decisions, these regulations, which is a relevant declaration, the Secretary of State has to start again. The Secretary of State has to put new regulations before Parliament, and Parliament has to decide whether to pass them through a negative resolution. And that is not a matter solely in the hands of the Secretary of State. And that is a reason for an exceptional public interest, need for parliamentary scrutiny, following a properly conducted lawful procedure by the Secretary of State. And in my submission, that's one of the reasons the C case is particularly helpful, because it deals with regulations put before Parliament where Parliament did not know the full position. And also, although not a criminalising provision, one that was enormously important, and perhaps alarming, because what it did was make lawful the use of force against children in order to make them obey instructions from staff, something that never been considered. May I turn next, please, to the case of Abid, which is tab 3 in the on page 65. This is a case in which section 31 of the Report Act was in play, and the relevant passage is paragraph 87 at page 79 onwards. In that case, there had been significant failings in the Home Secretary's decisions to maintain detention for a migrant. The facts were that, in fact, the migrant had been lying for 7 years or more about his nationality and status. And so, paragraph 88, the learned judge addresses the facts and finds that it's overwhelmingly likely that the Secretary of State would have detained the individual even had she known the truth, had she behaved properly. Then goes on. I do not refuse permission on the new ground and return to section 31, etc. Although it seems to me highly likely the outcome would not have been substantially different, and of course, pausing there, this is an outcome for one individual only. It's a decision affecting only one person. This is a case where 31(3)(e) is in play. As I stated earlier in this judgment, there is a great public interest in the state detaining people indefinitely for the purpose of effecting removal, only when the conditions for doing so are clearly made out. That was not the case here. It's wrong for casual and careless risk assessments to form the basis for detention. She then goes on to criticise the failings of the Secretary of State. Whereas here there have been errors of law, Article 89, in administrative detention there is an exceptional public interest in the court saying so and disapplying. And the court then granted the declaration. And in my submission, this is a case providing an example of where the exceptional public interest is engaged. There is an exceptional public interest in the state detaining individuals only where that is lawful, and in section 31 of the Senior Courts Act not being used to deny a remedy when that has not occurred. Now, in that case, a declaration is granted. The substantive remedy of damages was not. And my learned friends rely on that. But in my submission, that's neither here nor there. On the facts of that case, the claimant would have been detained in any event and therefore was not entitled to damages. And lastly, lady, I'd also now turn to tab 4,
Yes.
which is the Goring case.
Yes.
And that's again a planning issue. Like Abid, like Berkshire, a case in which only the Secretary of State was involved as decision maker. And in this case, it was planning permission and the development of wind turbines for hydroelectricity. And I asked the court to look at one paragraph, which is paragraph 47 at page 94. Again, this is dealing now with the section 30.2a duty.
Which paragraph again?
47, page 94. The Court of Appeal is at G to H says the duty from section 31.2a has regularly been applied to substantive decision making across the whole spectrum of administrative action, including the sphere of planning, both the first instance and the decisions of this court.
How does that help in the present case?
My Lord, the sphere of administrative action, and in my submission, the creation of criminal offences lies outside the sphere of administrative action. I refer only briefly to this case, my Lord. I'm very conscious that it doesn't deal with this precise point. But in my submission, this court should be very reluctant, essentially to validate the criminalisation of people through legislation that was unlawful in its inception until the end of May 2024. Legislation that created new offences by adding XL bullies to section 1 of the Dangerous Dogs Act and imposing conditions on them being kept which, if breached, led to a criminal offence. Because if you breach any of the conditions, for example, if you're away from home for 31 days, or if your dog doesn't like to check the doors, not in you or not in the public, it's an exemption granted by the regulations automatically lapses, and you're automatically in committing offence under section 1 of the Dangerous Dogs Act. And in my submission, the public interest, exceptional public interest, in ensuring that legislation of this sort is imposed only after an entirely lawful procedure is overwhelming and exceptional.
You've made reference on a number of occasions, and you make the point to your skeleton argument very helpfully, that there's this 3-month period from February to May 2024 when there hadn't been compliance with the PCD. But does it follow from your submissions that because you say the orders need to be quashed, particularly because of that 3-month period, that it would follow, since you're not asking us to limit a quashing order, if we could, I've never seen it be limited in time. So it would follow that people who could quite properly have been prosecuted and convicted in the many months since May 2024, they couldn't be, because the legislation will be held to be invalid throughout the entire period.
My Lord, that is the inevitable consequence. And the reason I've not put forward a suggestion that there should be some sort of limited form of quashing order is that I don't see how that can be done in parliamentary terms, because essentially you'd be altering, not quashing legislation, but altering legislation put before Parliament. And I do struggle to see how that would be possible.
So I don't want to be tendentious, but I just want to test the principle,
Yes.
test the legal argument, whether it's a right legal argument. Why should people who were properly convicted in, say, the early part of this year be able to take advantage of the fact that the court has quashed the legislation because it has concerns about a 3-month period, which has nothing to do with that.
My lord, because of the exceptional public interest, for all the reasons I've already set out, and one can see that in Riley. Undoubtedly, there were lots of people who perfectly properly were subject to sanctions in Riley, and who would have benefited from the declaration of question of relevant legislation. Because in Riley, the intention was that the legislation would force people who wanted benefits to do something for them. There would undoubtedly have been thousands of people who, with absolutely no good reason, refused to cooperate with the scheme, and were entirely properly subject to sanctions. They would have benefited because of other public overriding public interests. My lady, my lords, I'm very conscious that there are other authorities in the bundle which either side have relied on by way of an example or analogy. I don't propose to go further through them, but perhaps still can reply for them friend. Unless I can assist the court further.
May I ask you a question about the terms of the legislation that we're eyeing, which is in section 31, page 251 of the bundle. And in particular, you're invoking paragraph 2, capital B, page 252. And that actually confers a description. Do you have that?
Yes, I do.
It says the court may.
Yes.
Disregard, and you can read that, if it considers that it's appropriate to do so for reasons of exceptional public interest. Now, your submissions have very helpfully dealt with the exceptional public interest point. But do we need to be concerned about the fact that it begins the court may? In other words, that it confers a discretion. And here the High Court exercised that discretion against you. So what's the role of this court sitting on an appeal? Do we simply exercise that discretion again, or do we have to apply some other principle?
My lord, my submission, in fact, the High Court did not exercise that discretion because the learned judge found that there was no exceptional public interest. So she never got to the point of deciding whether, in light of that exceptional public interest, she should exercise the discretion.
I see. So what you're, I think, saying is that analytically, that provision, in fact, falls into 2 stages. The first is to make an evaluative assessment of whether there are reasons of exceptional public interest. And the second is, if there are, to exercise the discretion. Your submission is that the judge never reached the stage of discretion, and therefore we need not hesitate. What if we take a different view from her about exceptional public interest?
If the court takes a different view from the learned judge, my submission is that the court should exercise its discretion then not to apply to it.
That's really what, forgive me for not making myself clear, that's what I want just your help on. Do we simply make that assessment of exceptional public interest for ourselves, or do we have to ask whether the judge was, quote, wrong, unquote, in her evaluative assessment?
My lord, we are asking the court to find that the learned judge was wrong, to find that there was no exceptional public interest. And then, if your lordship is with us on that, my submission is that when the court has found an exceptional public interest, it should be very slow to exercise its discretion against a claimant.
Can I ask this? Suppose we're at that stage, or the court is at that latter stage of deciding, yes, there are exceptional public interest factors here. Now the discretion has to be considered. Would it be a relevant consideration at that stage that, as my lord has pointed out, we don't know the numbers, the effect of a quashing order would be to decriminalise a lot of conduct that may have taken place between May 2024 and the time of the quashing order, at the same time as affecting the period where we don't know what happened between February and May of 2024. before.
My lord, realistically, I have to accept it is a factor. It must be a factor. My submission is that it should not be a powerful factor. There is an overwhelming presumption that it's better that one guilty man go free than that 10 guilty men go free than one innocent be convicted. And that's perhaps generally addressed to the merits. But in this case, it is at least possible. It is, in my submission, almost certain that people have been convicted between February and May 2024. I'm simply looking at the number of dogs destroyed rather than indicates that. And secondly, because one cannot know whether this legislation would be passed by Parliament in exactly the same terms again, it is more than possible that individuals with protected characteristics that would be protected in new legislation have been convicted. And that is an immensely powerful factor, in my submission, in favour of applying the exceptional public interest.
Am I right in thinking these cases, the criminal cases, would have been exclusively in the magistrates' court?
Yes.
So any appeal would lie, I assume, to the Crown Court?
Yes. Except by the case stated tonight.
Of course,
Yes.
yeah. But people, let's assume that there is a cohort of people who have been convicted between February and May 2024. They now have the benefit of seeing the judgment of Mr. Justice Lang and what it says about the breach of the PSED during that period. So, on your submission, is there any reason in principle why someone in that situation could not apply to the Crown Court for leave to appeal against conviction out of time? I'm not saying they would be given it, but is there any reason in principle why they couldn't invoke Mrs. Justice Lang's judgment to argue that they were convicted in circumstances where they had a good defence and they shouldn't have been convicted?
My lord, yes. Two reasons why that would not be a satisfactory remedy. First of all, because the learned judge did not grant a declaration, there is no finding that the legislation was unlawful.
Waddington doesn't require a judicial review remedy at all. What Waddington says that you can raise as a valid defence the fact that the instrument under which you're being prosecuted is invalid.
My lord, I do accept that, but there is a practicality in it.
Yes.
There really is. I expect the vast majority of ex-al bullions prosecuted will have no idea of this submissions at all. And they should not have to. If legislation has been passed which has unlawfully criminalised them, the onus should not be on them to take action and to rely on a Crown Court giving them permission to appeal out of time, which may or may not be granted.
You would say also that a lot of people, however many were or weren't prosecuted and convicted, there are a lot of people who took action on the strength of the criminal law as it was then, by destroying their dogs or having them destroyed. So there are consequences that can't be remedied.
Absolutely. And that will also be true, my lord, of those who are prosecuted because if the court ordered the destruction of their dogs and there was no appeal. They have, between February and May, those dogs have been destroyed pursuant to an unlawful legislation. And that should be recognised by the courts, and it should not be for an individual to have to find the resources to bring a challenge. Unless I can assist the court further.
Thank you very much. Yes.
My lords, given the permission decision of Lord Justice Lewison, the premise of the appeal is that the general rule is applicable under, I'm going to call it 2 capital A, 2A. So the premise for the appeal is that the judge was entitled to conclude that it was highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. And that is because the judge had been entitled to conclude that although the original EIA or EIAs were not sufficiently detailed, the later EIA in May 2024 had properly and adequately considered the issues, and the result would have been and was the same. In other words, no change to the orders. You see her findings in that respect between paragraphs 112 and 123 of the judgment. In relation to the attempt made by my learned friend to seek to, as it were, broaden the 2A challenge through the back door marked 2B, I've said all that I want to say in relation to that in the concluding part of our skeleton argument, and I'm not going to take time on that orally. That's paragraphs 42 to 46 of our skeleton argument. So the question raised on this appeal, with that premise, is whether the obligation to refuse to grant relief that follows from that finding under 2A is to be disapplied, applying the discretion with its precondition that exists in 2B of the relevant legislation. And 2B, as you know, provides the court with that power, that is, the power to disregard the 2A obligation, if it considers that it is appropriate to do so for reasons of exceptional public interest. That's the language of 2B. And the public interest asserted, and for which permission to appeal was granted, is the public interest set out. Well, there's been some attempt to broaden it, and I'll address some of those, but it's the public interest asserted in the Appellants skeleton for permission, paragraph 11.1, namely that orders created criminal offences, and if those orders were unlawful from the time they came into force until the 28th of May 2024, then that provides the relevant exceptionality, the relevant exceptional reasons in the public interest. That was the effect of Lord Justice Lewison's order, so the appeal is narrow and is directed to that point. Just before coming to the few submissions that I have on that narrow issue, there is, as my learned friend accepts correctly, extremely limited authority on the nature and effect of 2B, and none of it, I respectfully submit, is of any real assistance in terms of the analysis of the courts in prior cases as to the principled approach to, or the parameters of, the core concepts in paragraph 2B. Plainly, at its heart, the test in 2B is in any event context and fact specific. We've dealt with the majority of those cases insofar as it's suggested that they're relevant in our skeleton argument. And I don't go back to what we said in the skeleton in relation to that. At the end of my submissions, I'll deal very briefly with a couple of the authorities which my learned friend has relied upon, including in particular the Riley case and the C case, if I may. We make 6 submissions in relation to that narrow issue on this appeal. The first of them is that the test in 2B is one of reasons of exceptional public interest. That is, and this is our first submission, a strong requirement imposing a high hurdle. That strength of the test, the height of the hurdle, is indicated by the fact that certification is required if the court does reach that conclusion. It's actually required to certify things, but that's its conclusion. that's the requirement that flows from 2C. I'm sure the court won't need to go back to that. If the court grants relief in reliance on sub 2B, the court must certify that the condition in 2B is satisfied. So you actually have to produce a certificate saying that there are reasons of exceptional public interest. That's the condition that is referred to in 2.
Do you mean a certificate in a formal sense, or is it enough that you say that in your judgment?
Well, my lord, that may be a bit of an open question. I suspect that the court may need to say in its judgment, we certify.
Yes.
Court might be wise to use the words that Parliament has required. But as a formal process and a formal outcome, wherever that happens to be, I'm not suggesting that imposes a requirement on a court to wave around some piece of paper, because if that was the requirement, you'd expect to see the form annexed to the legislation. So I think it would be enough to deal with it in the judgment. My point, however, is that that's an emphasis of the exceptionality that is truly being aimed at by Parliament, because it imposes that requirement. No doubt the framers of the legislation were concerned that the court should keep a very weather eye, if I can put it that way, on the adjective that precedes public interest, namely exception. But the certification requirement is a discipline which is imposed by the legislation, however conformed to, and is of significance to the height of the hurdle. The second thing that we rely upon by way of this, still in this first submission, but the second matter that is indicative of the strength of the requirement is the fact that 2B itself sits as an exception to the obligation, the new obligation in 2A. So as my Lord Justice Singh has already pointed out, what this legislation did was to move from the previous simplex position, to move from the position where these matters were discretionary, as it were, and it then created a new obligation on the courts to refuse a remedy in public law cases in circumstances in which the precondition in 2A was met. In other words, if the decision was highly likely to have been the same without the error. And the question then is, under this statutory scheme and under the structure of the new section, the question then is whether, despite that fact, in other words, despite the fact that the court has already concluded that it's highly likely that the decision would have been the same without the error, the question then is a remedy still required because of exceptional public interest?
It's rather curious wording, if I may respectfully say so, because as Mr. Guy has emphasised, actually what the legislation says is for the applicant. So not in the abstract, but for the applicant. That's how 2A is framed, as you say, the duty. But then when it comes to the carve-out, if I can call it that, in 2B, it no longer refers to the applicant, but starts talking about exceptional public interest. And so, I don't know, there may be some significance in that. You may end up having to give, or in fact, give a remedy to an applicant, because who else are you going to give it to? That's the person in front of you. Because of the impact on
Others.
Exactly, on others. That's the submission. I'm not sure. I don't know if you accept that that's a correct analysis of the wording.
My Lord, I do accept that the section is structured in that way, and my submission is that the structure is deliberate. The focus in the individual case is on the applicant, and highly likely that the decision would have been the same. We know what that means, and we know what that means because the Court of Appeal has considered this recently. I think it's the authority that I handed up and should be on your bench, which I'm sure, or I know my Lord Justice Singh will be very familiar with, the Bradbury decision, that revisited what Section 2 capital A is doing and analysed with some precision what the nature and focus of that required judgment is. Maybe worth just picking that up as part of the answer to this point. I was going to come back to Bradbury anyway, but if you go in that, you'll see the context. Just cast an eye over the head note, if you will, or the fact bit of the head note. So pretty similar to our case, although ours was an EIA, not a habitats assessment. But the relevant decision maker hadn't taken it into account, and then they did one and did take it into account and concluded that the same outcome would have followed. So those are the facts. And then the judgment of the court, so far as relevant, is really in paragraph 70 on page 15, using the page numbering on the bottom. And if you just cast an eye, rather than me reading it, if you just cast an eye, if you would, down 70 through to the end of 73, but the key paragraph perhaps, because this is the correction that the Court of Appeal was intending to effect to the previous analysis of the lower courts, it appears. So 74 is the key paragraph, but you get there via 71, 72 and 73. Can I just invite you to read to the end of 74, therefore?
Is 70 important? Because it's in that paragraph that Lord Justice Lewis says that the outcome for the claimant is usually the decision or other measure that the public authority has taken. And the difference between you and your learned friend seems to be that she focuses the attention on the outcome for the claimant being, well, nothing would have changed for this particular individual.
Yes.
You've put it in different terms, saying the decision. That's to say the decision.
My lord, that's exactly the point I take from this case. It's a combination of 70 and 74. So my lord is right to put to me, my Lord Justice Singh is right to put to me, that the language, as it were, is specific in 2A, at least on one view of it, because it refers to the applicant, and more general in relation to the public interest references in 2C. Part of my riposte to that is you need correctly to analyse how 2A actually works. And although it refers to the applicant and the outcome for the applicant, in the end, when you apply the reasoning of the Court of Appeal in Bradbury, which I respectfully submit is correct, what you're actually doing is to focus in on the decision. So would the orders still have been made?
Well, quite. And speaking for myself, I would not disagree with what you just said. It seems to me that one crucially has to keep in mind that administrative law deals with a whole host of different types of decision, all of which are amenable to judicial review.
Yes.
And in some cases, it'll be an individual planning decision which affects one applicant, one plot of land. At the other end of the spectrum, we have cases like the present one, where you have secondary legislation, which in principle affects the entire public.
Yes, my lord, one can put that same point in a variety of different ways by reference to the structure of the statute. There will be some cases in which the reference to the applicant in 2A is really to be taken as just a reference to the applicant, and then you go to 2B to see whether there are any broader public interest concerns. There will be other cases where you effectively apply, because then the decision and the applicant, as it were, coincide. In that sort of case, there will be other cases, as my lord points out, where the focus that is required in Bradbury does itself require you to answer a question which is about general legislation. by the
which
audit
has general implications.
and has general implications. And then
Do
the,
we know
Which
about Bradbury? Sorry.
Sorry,
Sorry.
which affect the applicant as part of the sort of, as it were, the general code.
yes, exactly so, my lady. And that so it's not as simple as saying, as she purports to say. Well, it's not as simple as saying, well, that's the applicant, so now I can kind of bring in a new 2A argument in through the back door. It depends what you're dealing with. It depends what the decision was. Is it simply restricted to the individual applicant, in which case there's one thing there, and then you ask whether there's a broader public interest. Take the Helen Mountfield QC decision. You'll remember that one about the immigration detention. An individual applicant, but nevertheless, if you leave aside the other kind of egregious bits about careless decision making, nevertheless a genuine question around whether or not that sort of thing raised issues of a more general public interest. But here you're into the, if I can put it this way, you're into the general, because of Bradbury's analysis, at the earlier stage in 2A.
And if we apply that to the present case, is
Yes.
it your submission that what Mrs. Justice Lang has held is that once a compliant EIA was done from May 2024 onwards, she wasn't saying, as I understand her, she's complied with the law only in respect of these applicants. She's saying that I'm confident that it's highly likely that the outcome would be no different for anyone.
Yeah, she's not merely saying that in terms of the breadth of the people affected. My lord is entirely right. I agree, but she's also doing the exercise which the section requires, which is to some extent a retrospective one. Would the decision here to make the orders have been the same? And if the answer to that question is yes, what the statute does is in effect to deem those lawful from the date made, because the court is obliged to refuse relief, even if there was a flaw in the decision making, in fact, before they were made or at the time that they were made. That's as it were the fiction within the section. But so it's got a temporal aspect as well as a breadth aspect. Anyway, that's my first submission about how the section works internally. It's a high hurdle, A, and B, we don't accept that this is just a recipe, as it were, to reopen 2A through the guise marked 2B. The way it works is, as per Bradbury, to focus on the decision, para 70 and para 74. If you focus on the decision here, order made, order would have continued to be made. Mrs. Justice Lang has made that judgment. And so when you come to public interest, you're asking the question, what's the public interest? What are the general and exceptional public interests that apply in circumstances in which, if the public law error had not been made, the decision, i.e. to make the orders, would have been exactly the same. That's the first point. The second point is this, and I make it relatively likely because it has got an element of bootstraps about it, but I make it anyway. In this case, it is absolutely clear, and now uncontested because of the limitation on the permission to appeal, that the decision would indeed and clearly would have been the same. That is because when the flesh was put onto the EIA bone, the potential disadvantages were properly and fully considered in terms of those with protected characteristics, and the conclusion that was reached was that that did not justify any change to the position in relation to the orders. And that, no doubt, was significantly affected by the fact that those orders had as their fundamental and driving basis the protection of the public from dangerous dogs. So not merely is that absolutely clear on the judge's findings, but also finality was achieved, if I can put it that way, in a lawful way. And so there's nothing broader in play anymore. So the exceptional circumstances in this case fall to be judged against a backdrop of the particular clarity and finality that was achieved when the legal correction was made, as it were. and there is therefore no broader need or public interest in a remedy being granted now. Third point, in this case, reliance is placed on the possibility of criminal charges. My submission is that the case that my learned friend has to espouse has to be an extreme one, that any such scheme with criminal sanctions attached would in all cases create exceptional public interest. I'm going to come back to that point as a discrete point, if I may, in due course. But that is because the criminal charges point does not go anywhere on the facts for the following reasons. There was no evidence of any prosecution based on the orders adduced by the claimant. It can be said, well, we simply don't know whether there would have been prosecutions or there wouldn't have been prosecutions, and not much of that information is available. But my learned friend below made much of the fact that her case was being brought, as it was continually put, in the public interest, as public interest litigation. There were lots of statements produced from various affected members of the public who were concerned, and no one produced anyone, despite the publicity given to this litigation and despite the crowdfunding it was able to achieve, no one produced anyone who'd actually been prosecuted. So there was no evidence, in fact, of any prosecution based on the orders. There was nothing to suggest, and no case advanced before the judge, that any such prosecution, even if it had occurred, was or would have been rendered unjust by this failure to consider the detail of the EIA earlier. There was no evidence or suggestion that prosecutions flowing from facts in the period in question would have caused injustice, and I'm talking about an extremely narrow window for this purpose. Just for your note, it is perhaps worth bearing in mind, I'm sure our skeleton is a model of clarity on this point at least, but the offence is created, as you'll have appreciated, in the Dangerous Dogs Act 1991, section 1.3. That's in the authorities bundle at page 262. But that offence applies from the appointed day, and by virtue of Article 3 of the designated types order, not quite sure what page number that is electronically, but it was behind tab 16, at least in my bundle, but it's a designation order, it's the designated types order of 2023. The appointed day is the 31st of January 2024. And as you will recall, the revised and adequate and lawful EIA was considered and approved by the Minister on the 28th of May 2024, so a period of about 4 months. And it is to be borne in mind in considering, as it were, allegations of broad injustice flowing from criminality as the basis for exceptional public interest reasons, that a criminal offence is only committed, and therefore criminality only flows, from a failure or a positive decision not to comply with the legislative requirements. That's the only circumstances in which you will act criminally. Finally, in relation to this point on the facts, if there had been a prosecution, it does not automatically follow that unlawfulness from non-compliance with the PSED until May 24 doesn't automatically follow from that fact that prosecutions would have been themselves unlawful. The principle is more nuanced than that. Again, without wishing to divert too far from the path in oral submissions, we've referred you in our skeleton to the Majera case, the well-known Majera case, Lord Reed, considering the impact of unlawfulness in public law. I don't want to go back to that decision, which will be very well known to the court anyway, but the basic point that is being made by Lord Reed in Majera is don't jump too quickly to an assumption that public law error or unlawfulness renders the decisions or the legislation in question automatically void. indeed the principled approach per Majera, is that public law decisions and legislation are presumed to be and to continue to be lawful unless and until they are set aside and to have legal effects, unless and until they're set aside by an order of the court, presumably the administrative court more often than not, but a court of competent jurisdiction. And we've given you not merely Majera in our skeleton argument of paragraph 36A, but also the well-known principle from Datafin. I think it was Sir John Donaldson when he was Master of the Rolls in Datafin. That isn't in the bundle, but it isn't in the bundle because I'm told my learned friend Miss Maguire kindly accepted the correctness of that principle. And the principle is, as we've there set out, entirely consistent with Majera. As Sir John Donaldson put it, however wrong they may be, however lacking in jurisdiction they may be, they subsist, that's the public law decisions in effect, and remain fully effective unless and until they are set aside by a court of competent jurisdiction. So that point exists. It isn't automatically unlawful. The thing doesn't automatically collapse. And nowadays, whether or not a court decides to do so, whether or not the court of competent jurisdiction does decide to do so, in other words, to quash the thing or to describe it as void or produce a declaration that it's unlawful and void with the consequences that my Lord Justice Singh has already drawn attention to, flowing from that type of declaration, it is now affected not just by the finding of unlawfulness, but by the statutory rules which govern the exercise of the remedial discretion, including now the obligation in 2A with its cutout in 2B. So no assumption of criminal process unlawfulness can be made, even if a prosecution was made. And as is now accepted, the position is in any event that it is permissible and possible for people to raise collateral challenges under the principle in Boddington, so that you can argue in a criminal prosecution, if a criminal prosecution is brought, that the order itself is unlawful.
Do you accept that in this context, the Boddington principle would punish a defendant potentially?
I do.
To raise the suburb defence?
I do. I accept that, and perhaps for present purposes more relevantly, I also submit that it would be highly relevant to any criminal court's consideration of Boddington or an attack that is made through Boddington. It would be highly relevant to consider the remedial position under 2A and 2B. And if you had, for example, if a prosecution only came to court after the judgment of Mrs. Justice Lang had been produced, it would be highly relevant to know that a court of competent jurisdiction in that jurisdiction had decided that no remedy was appropriate because the outcome would have been highly likely to have been the same. In other words, the orders would have been maintained. Because Boddington doesn't dictate how a criminal court goes about doing that, it simply opens the door. But it's inconceivable, in my respectful submission, that a criminal court would not regard that remedial position, particularly in the light of Majera and of Datafin, would not regard that remedial position as being highly relevant for its purpose.
Right, James, we will resume at 2:05.
I'm so sorry.
If there are any difficulties which you observe still going on as you leave the building,
We'll try and get back
please
earlier.
do pass a message on so that we can give you more time.
I'm very glad it got through before, so thank you.
So everybody has a chance to have an appropriate break.
Thank you.
Sit again at 2:05.
What rank, please?
Nina from the Press Association. Hello, wondering if you might spare a copy of your